Welcome to Bonafide Dialogues with Christina Kueppers. Explore our three segments: legal tech, creativity, and paradigms and paradoxes.
Connect genuinely, broaden your perspective, and share your passion.
Mr. Grossman is a founder of Intelligent Justice. He is an experienced trial lawyer, focused primarily on complex business litigation and alternative dispute resolution. His practice has included legal disputes covering a broad range of issues, including business fraud, antitrust, contract disputes, trade secret litigation, licensing disputes, class action litigation, real estate and construction disputes, employment and intellectual property litigation. Mr. Grossman has appeared before federal and state courts at both the trial and appellate court levels. He was the chairman of his prior law firm's litigation practice. Concern over the extraordinary cost, delay, and inefficiency of obtaining justice in the public court system motivated Mr. Grossman to seek better dispute resolution alternatives and ultimately led to the creation of Intelligent Justice. He has broad experience in arbitration and mediation procedures, but he is especially passionate about the virtues of Intelligent Justice's Comprehensive Adjudication, which provides the most cost-efficient path to a fully analyzed, thoughtful, and just resolution of legal dispute. Notable cases: UFCW and Employers Benefit Trust versus Sutter Health. Lead counsel in a groundbreaking antitrust class action battle against Sutter Health, the dominant hospital chain in Northern California, on behalf of a certified class of employers and other self-funded payers who were overcharged for healthcare services provided to their employees as a result of Sutter's anti-competitive contracting practices. Result: $575 million settlement for the overcharges imposed upon the class, plus at least 10 years of comprehensive injunctive relief to prevent future anti-competitive behavior. Antitrust litigation against Microsoft. Multiple cases on behalf of Microsoft's software licensees and a separate case on behalf of a competitor for unlawful restraint of trade and unfair competition in the operating system and key business software markets. Microsoft cases: co-lead counsel in an antitrust class action on behalf of Microsoft's business and consumer licensees in California. Result: $1.1 billion settlement. San Francisco versus Microsoft: co-lead counsel in an antitrust class action on behalf of Microsoft's government entity licensees in California. Result: $70 million settlement. Gordon versus Microsoft: co-counsel in an antitrust class action on behalf of Microsoft's business and consumer licensees in Minnesota. Result: $182 million settlement after 6 weeks of trial. Sun Microsystems versus Microsoft: co-counsel assisting in antitrust claim on behalf of Sun Microsystems. Result: $700 million settlement.
Thank you very much for joining me today. Can anyone truly protect their rights in this country? Is achieving justice possible?
Well, thank you, Christina, for having me. I'm delighted to be with you today. Our public court system is extremely flawed, and I know this because I have been a participant in that system for many, many years. I participated in that system as an advocate for plaintiffs that had very legitimate claims and were legally wronged and deserved relief. I also represented defendants that were the victim of improper claims, illegitimate claims, and needed to be defended. In every one of those cases, the public court system let the parties down. What do I mean by that? Well, in most of those cases, I was victorious on behalf of my clients by the standards of our public court system. We achieved most of the goals that we sought out to achieve in the litigation. But did we achieve justice? Justice. And I think the answer to that is not always. The reason is because our public court system is so inefficient, it is so costly, it requires so much duplication of effort. Attorney's fees are too high. It takes years to achieve a result that is final and enforceable. And the risk of an unjust outcome is far too high and unacceptable. And so we have a system where the cost of pursuing a just outcome is rarely worth the benefit that one could possibly achieve, even if you're victorious. So while I achieved victories on behalf of most of my clients when I was a legal warrior, an advocate on their behalf, did I achieve justice? I have to question that. If they have to pay too much money in legal fees, if they have to, if it requires years to obtain that victory, if the risk of an unjust outcome is too high to gamble on a judge or a jury deciding it, then that's not justice, and it's not a proper justice system. And so I have, because I've been disheartened by that, because I actually care about justice and bringing justice to our society and making it available to those that have been wronged, I decided to come up with a better system that makes it affordable to swiftly get to the right outcome in a legal dispute, and does it in a way that is cost effective, is swift, and is just. I call it comprehensive adjudication, and we can talk more about how it works.
Learn more at casesresolved.com and intelligentjustice.org. Consider Comprehensive Adjudication provides a more expertly analyzed enforceable decision in less than half the time needed for litigation, at less than half the cost required for litigation. The total cost is capped in advance.
I know that you have been practicing law for so many years. How many years actually have you been practicing law?
Over 40 years I've been practicing.
Over 40 years, yes. And you worked on so many important cases. But do you think that this new system that you will be talking about in a moment is applicable to any case, or specifically to those large cases?
Comprehensive adjudication, this new system that I came up with, can be utilized in small cases or large cases on almost any subject involving any area of the law. So it can be utilized in a divorce dispute. It can be utilized in a dispute over a will or an employment dispute with your employer. It can be utilized in large antitrust cases, in patent cases. It can be utilized in contract disputes between individuals or between corporations.
Public court litigation requires many years to complete because an enormous amount of time is wasted on procedural battles. Comprehensive adjudication eliminates that wasted time by focusing exclusively on the key legal and factual issues. Mr. Grossman dedicated significant time to litigate some cases. At times, it took years. While he is proud of his successful outcomes, he wishes the process didn't take as long. Here is an example from his practice.
I'm proud of almost all the cases I work on because I have had the luxury of choosing the causes that I wish to advance through my legal advocacy when I was acting as a legal gladiator on behalf of my clients. But yes, I have been involved in some cases that were very complex and required a long time to recover. I worked on behalf of an inventor who came up with a fabulous energy-saving lighting technology in many, many years ago that would have saved 30% of our energy costs over the past several decades if it had been implemented. It was then licensed to a large company that had an old energy wasting technology that it was selling, and it promised its best efforts to bring it to market. But what it did, instead of using best efforts to bring it to market, the energy-saving technology, it buried it. We filed a lawsuit to bring that technology back to the public and to recover the losses that the inventor sustained as a result of that case. We tried it and won $28 million. That got reversed on appeal because of an evidentiary issue. We had to go back and try it again. And the second time we tried it, we won $96 million. That was ultimately sustained on appeal up to the California Supreme Court. But before we were able to have a final judgment that was enforceable, it took 14 years. And, a large part of the client's recovery was paid in attorney's fees. You can imagine what they were over a period of 14 years of full-time work.
And the technology that he created was probably no longer as important as it was 14 years ago, right?
It was buried during the time when it would have been most useful. So is that justice? Yes, we won. Yes, we won a lot of money. But is that justice when it takes 14 years to get to a proper result? And is it justice when the vast majority of the recovery goes to the attorneys? I would say it is not.
And so many people won't be able to pursue such a long lawsuit. To make it a part of your budget, you really have to sacrifice so much in life. And most people won't even do it, then they will look at the financial aspect of that. They would say, I can't protect my rights in these situations. I can't afford it. It's not justice. If you can't even go to court to protect your rights, knowing how much it's going to cost.
Absolutely. And that is the problem. And it was worthwhile when there was so much at stake that the attorney's fees didn't eat up the entire recovery. But I cannot tell you how many times I had to advise potential clients the cost of pursuing a just outcome will approach or exceed the benefit that you could possibly obtain many years down the road. And so I would decline to take cases, even some very large cases, because it was not worth the client's investment of time and energy and cost to obtain what would have been a proper result, but a result that would have been eaten up by attorney's fees, delay, and the risk of an unjust outcome.
Yeah, it's not always only attorney's fees, right? There are experts involved. If there's a discovery stage of litigation, can be extremely costly. So yes, how can you predict? It's not always even possible for you. Then I assume then you advise your clients or potential clients. If I come to you tomorrow and say I'm in this situation, how much it's going to cost? Like, it's hard to make that assessment. And if it takes 14 years, or even 4 years or 5 years, how can you possibly give that advice? So something is really wrong with our system.
I agree. And it's not the fault of the attorneys. The attorneys are working within a system that motivates and incentivizes inefficiency, incentivizes battle and advocacy, as opposed to incentivizing a swift and cost-effective system for obtaining justice. And so I challenged myself to come up with an alternative. What would I replace our current system with?
What can we do? It has to be changed.
Well, in order to understand the solution, you have to understand the problem. And let's just talk about why it costs so much money to pursue a just outcome in our public court system. The principal reason is our public court system is structured around, it depends upon each of the parties to a dispute hiring separate lawyers that all review and research the same legal authorities, that examine and review the same evidence, that examine the same witnesses in depositions, in discovery.
Right, but they look at the case from the different perspective, right? They want to protect their client's rights. So they look at the evidence and they're seeing different things. So I want to have my attorney, to protect my rights and look at the evidence and see something that can be helpful to my case.
Well, Christina, I disagree with that, because good attorneys that are advocating for their clients look for all of the evidence and all of the law, whether good or bad. So my job as an advocate for my client's interests is not just to look at the good evidence and ignore the bad evidence that my opposition is going to present. It's my job to also look at the law and the legal authorities that are not favorable to my client, as well as those that are favorable. If I ignore the arguments that are going to be difficult for my client to oppose, then I am not doing my client any favors. Yeah. So what you don't see is that behind the scenes, good attorneys are looking at the law and the evidence that favors their clients, but they're also looking very hard at the law and evidence that disfavors their clients. And they are quietly advising their clients, if there's a problem with their case, that they need to consider resolving the case or settling it. That's what good attorneys do. And so all of that work is done by the attorneys for the plaintiff, and it's also done by the attorneys for the defendant. They both look at the law that helps them, and they both look at the evidence that helps them. They also look at the law and evidence that hurts them, and they analyze it and advise their clients. The only thing that you get by having a separate counsel advocating on your behalf is that they tend to emphasize the legal authority and the evidence that supports your position.
Absolutely.
They emphasize it, but they can't ignore the law and the evidence that hurts their client's position. And so all you get is emphasis. And, for some people, they may think that's worthwhile. And I urge them to waste their time and money in the public court system because the problem with having a legal gladiator on your side is that the other side also has a legal gladiator emphasizing the law and the facts that support them. And they tend to cancel each other out. And so wouldn't it be better, more efficient, more cost-effective, faster, and more accurate to have a legal system where we weren't emphasizing the battle between legal gladiators?
But then you don't see different perspectives, right? You have two people and they're looking at the same situation from different perspectives. So then the judge can listen to both of them and find the truth. And of course, the evidence as well.
Well, perhaps we should talk about the solution that I've come up with because it solves that very problem. The public court system relies on separate advocates making presentations to a judge or jury in a battle before the judge and jury that they hope to win on behalf of their clients. My solution is that's a waste of time. It's a waste of time and effort. And it would be better to simply hire an adjudicator, someone with expertise in the area of law that's relevant to the dispute, and someone with expertise in reviewing the evidence, analyzing the evidence, examining witnesses, and getting to the truth, to look for all the law and evidence that support the claimant, and just as zealously look for all the law and evidence that support the defendant, and then decide the dispute so that you have a neutral, someone who doesn't care whether the plaintiff wins or the defendant wins, but just wants to quickly and efficiently, cost effectively get to the proper result. That would be a more efficient, much more cost-effective system for obtaining justice for either the plaintiff or the defendant, whoever deserves to win. And that is what comprehensive adjudication is about. Comprehensive adjudication eliminates the legal gladiators. It eliminates the lawyer's role of...
And it comes from the lawyer, so...
Well,
I mean, what you're doing is great, but you're an attorney and you're saying we need to eliminate attorneys from this process.
I'm saying what we need is less legal gladiators involved. Who are going to be the adjudicators that have the expertise in a particular area of the law, that have the skills to examine the evidence and distill the facts, that have the skills to cross-examine witnesses and get to the truth? Those people are the very litigators that in other situations act as legal advocates. But here they would be acting as neutrals. They would be hired jointly by the parties, jointly interviewed and selected by the parties for their expertise, their neutrality, their integrity, and their skills at uncovering the truth and quickly deciding what the just outcome is. And so lawyers will be very much involved. They'll just be involved in a much
different roles. Yeah.
Be involved in a role as an expert, as a neutral expert whose job it is to quickly, effectively, and cost effectively get to the proper outcome without excessive delay, without attorney's fees, and without the duplication of effort that's required when you have separate attorneys for each side, all examining the same evidence, researching the same law, attending the same hearings, examining witnesses at the same trial. All of that wasted duplication of effort can be eliminated if we hire a single adjudicator who is neutral, who does all of that work. But instead of the parties paying separate counsel to duplicate each other's efforts in doing all of that work, they split the cost of that single expert adjudicator. And by doing that, we immediately cut the cost to each of the parties in half or less. And so instead of paying lawyers for each side to examine the witness, you pay an adjudicator, an expert, to examine the witnesses and get to the truth. And you split that cost of that single adjudicator instead of paying two lawyers to examine the same witness.
Right. And I really liked one of the points you just made, and it's about adjudicators being experts in those areas that are being examined. It's very difficult for anyone, if you're a judge, to become an expert in every single area. And there are many, many complex cases. For example, in the technology field, you would see so many complex cases, and you really need to understand a lot about this field and about this area, and sometimes specific issues to make a fair and just decision, right?
I agree. And, every judge was formerly a practicing lawyer. And most practicing lawyers had to specialize in a particular area of the law. So if you have a judge whose experience was in employment law, would you want them to be deciding a patent case involving science and technology? If you have a judge that specialized in divorce, would you want them deciding an antitrust case with all the economic issues associated with that? And vice versa. If you had an antitrust lawyer, would you want that lawyer to be a judge in your divorce case, where there might be child custody issues and other issues that involve psychological evidence? All of these legal specialties require, in order to practice law in those areas, you have to have specialized knowledge and experience. Well, as you point out, somebody becomes a judge and they're assigned to all kinds of different cases in all kinds of different legal specialties. And we expect them to be experts in that. Yeah. What we do with comprehensive adjudication is the parties have the ability to hire a patent specialist to be the judge, the adjudicator, if you will, of their patent dispute. You can hire someone that is experienced in domestic relations to be the adjudicator of your divorce dispute. You can hire someone that has experience and expertise in employment disputes.
These are licensed attorneys, right?
Licensed attorneys to be the adjudicator in your employment dispute. And so you get someone that starts out with expertise in the specific area of the law. The other problem, there are other problems that, increase the risk of an improper result. One is that the judges, can't possibly have specialization and experience in every field of law. The other is that we entrust many of the decisions in a legal dispute to jurors who do their best to understand the evidence and do their best to understand the law, but they are not trained in the law and the evidence. And so they are, unacceptably prone to making decisions based on their prior experiences in life and their biases. And so we have decision makers that don't have expertise in the areas that they need to make decisions in, making those decisions, and those, that increases the risk of an unjust outcome to the point where people are unwilling to roll the dice on a trial because they're concerned about the unacceptably high risk of an improper outcome. And So how do we solve that with comprehensive adjudication? We say at the beginning, if you've got a patent dispute, then the parties will interview experts in patent law.
This is great. This is great. I think this is so important. Yeah.
And they will jointly interview their adjudicator candidates and can make selections based on their experience, their expertise, their integrity, their neutrality, and their diligence in working hard to get to the bottom of a case quickly and inexpensively. That is what we're looking for with the folks that we want to decide our cases. And that is one of the tremendous benefits of comprehensive adjudication. But
yeah, so the first benefit, as I hear what you're saying, you're saving a lot of money. Second, you're actually can agree on an adjudicator who is specializing in specific area of law and maybe even has experience in that specific field. And the third one, you said that it can be, the matters can be decided much faster. How would you achieve that?
Well, let me explain the problem with the public court system.
Yeah.
There is enormous duplication of effort. It is enormously inefficient, and that falls in three areas. Let me quickly explain what they are. First, as I said earlier, you have lawyers for each party researching the same law, reviewing the same evidence, examining the same witnesses, attending the same hearings, examining witnesses at the same trial. While one is examining the witness, the other is sitting there listening. But the parties are paying for both of them to do this work.
Right.
What comprehensive adjudication does is it consolidates all of that work that's being duplicated by the separate counsel for separate parties into a single adjudicator who looks for all the law and the evidence that supports the claimant, as well as all the law and evidence that supports the defendant, and then just decides the dispute.
Wouldn't it take longer for one person to do all of this? Then you have like so much effort from both sides? No?
No, absolutely not. Because having two sides do it requires more time. But let me explain the second area where there's duplication of effort. In our public court system, the lawyers for each side first have to uncover the evidence, the documents, the electronic records, and they have to examine the witnesses in what we call discovery proceedings. And those are long, complicated proceedings where depositions are taken, where documents are subpoenaed, where there are fights over the proper scope of subpoenas and the proper scope of depositions. And then after all of that evidence is collected, witness testimony and documentary evidence, the parties, the lawyers for both sides, take that evidence and they make presentations to the court in the form of motions to the court, all kinds of different motions that are necessary before a trial. And what do is they present that same evidence and that same testimony in motions to the court. And then after those motions are decided, they have to present that evidence again to a jury at a trial several years later. And so there's yet another presentation of the testimony and the evidence. And then after there's a decision at trial, they have to present that same evidence again when there's an appeal. And they present that to a separate appellate court, the law and the evidence. And so you have multiple presentations of the law and the evidence to a whole variety of audiences in order to get to the point where you have a final decision. Comprehensive adjudication eliminates all of that duplication. The adjudicator starts the trial, if you will, immediately. Immediately after the adjudicator is hired, the adjudicator looks for and obtains all of the documents, all of the electronic records, and examines all the witnesses under oath. We don't need to repeat that presentation again. The adjudicator, the person who is responsible for deciding the dispute, has already seen the evidence and has already heard the testimony. And so instead of duplicating these presentations over and over and over again with all kinds of delay, years of delay in between, the adjudicator starts the trial right after the adjudicator is hired, finds the evidence, examines the witnesses, and decides the case. And that's how we cut the time involved. There's one more area, and that is in our public court system, because it's an adversarial system, the motivation of the lawyers is to seek every procedural advantage on behalf of their clients. And so there are all kinds of lengthy, expensive, unbelievably expensive and time-consuming disputes over such things as jurisdiction, venue of the court, discovery disputes over the proper scope of discovery, experts and whether expert witnesses are appropriate, scheduling disputes, confidentiality disputes, disputes over attorney-client privilege and the like. And the list goes on and on. None of those matters, none of those disputes that are the subject of all kinds of expense and time have anything to do with the substance of who is right and who is wrong. It's all about legal gladiators seeking some sort of procedural advantage for their clients. And sometimes they succeed, sometimes they don't. Sometimes one succeeds in this area and another succeeds in the other area. But none of that has to do with who's right or wrong.
Yeah, it's especially gets interesting when you have two experts, and they they have completely different opinions, and you have to pay to both of them a lot of money, and then the judge has to read, and you have these two very well-known, often very well-known individuals that specialize and dedicated their lives to specific area, right, that they're expert at. And then judge somehow has to decide, is this expert right or this expert right? Who is wrong if they're both highly knowledgeable individuals. And this expert testimonies and expert reports are very, very expensive, and it's a lot of research involved. It realistically, it should be done only once, right? Because if you have two expert reports on the same issue, how do you think judge would have that much power to say what this expert, he's expert, right? He dedicated all his life to this topic, for example, and judge would say, no, you're wrong. This expert is right. It's kind of nonsense, isn't it?
Well, let me address the issue of experts because you make some very valid points. But let me first finish the point about procedural motions and disputes.
Okay.
Comprehensive adjudication, the system that I have come up with, eliminates all of that. Because you don't have legal gladiators for each of the parties seeking some sort of procedural advantage on behalf of their parties, there is no procedural advantage. There's a single adjudicator. That adjudicator is looking at the substance of the dispute and doesn't care about trying to find procedural advantage for one party or another party. It's not relevant. It's not even part of the process. And so we eliminate all of those disputes over jurisdiction and venue and discovery scope and admissibility of evidence and all of that. is eliminated, and that saves enormous amounts of time and expense. Now, to your question of experts, let's back up and talk a little bit about what expert witnesses are. Ordinarily, a witness in a trial can only testify about something that they actually witnessed, something that they saw with their own eyes or heard with their own ears. And because they have to have what we refer to as firsthand knowledge of the facts of the dispute. However, there is something that we use in the public court system, which is referred to as expert witnesses. These are not witnesses that testify about something that they actually witnessed with their own eyes or their ears. They have particular expertise in something, in a field that is beyond the understanding of regular, ordinary persons. And so you want to hear their analysis and their opinions about the facts that they have been presented with because of that highly specialized knowledge that ordinary people don't have, including lawyers. And so, for example, in a patent case, you might have an expert witness who is a scientist and has specialized training, knowledge, and expertise in a particular area of science that ordinary people don't know or necessarily understand. And you want to hear their analysis of the evidence.
Relevant to the case, and it's very important.
Same thing in a child custody case. You want to hear expert testimony from a psychologist who has evaluated the psychology of the mother and the father and the child. Similarly, in an antitrust case, you want to hear the analysis of an expert economist who has looked at the economic issues that are beyond the understanding of ordinary people, and hear their opinions about the evidence that's been presented. You're right, Christina. In our public court system, each side hires an expert that has an opinion that supports their view of the case and their client's position. And the other side has an expert that supports the other view. And you have these two opinions that clash with one another, and neither of them is about trying to get to the proper result in the case. It's all about this adversarial process of one opinion versus another opinion. One attorney's emphasis on certain facts versus another attorney's emphasis on certain other facts. One attorney's emphasis on certain aspects of the law and another attorney's emphasis on another aspect of the law. Wouldn't it be more efficient, faster, less expensive to have a single adjudicator who's looking at both sides of the case, who doesn't care whether the plaintiff wins or the defendant wins, but only cares about getting to the right result and doing
they can agree on one expert, right?
Well, exactly. In other words, the parties, if an adjudicator believes that there is something involved in the case that is beyond the adjudicator's understanding or ability to comprehend, something involving science or psychology or economics or some other specialty, then the parties can agree that the adjudicator can hire someone with expertise in that area and hear the opinions of that expert in connection with the adjudicator's decision on the case. But we don't need to hire two experts that automatically opposing opinions that are just going to cancel each other out. And so again, this is another example of waste in our public court system. What is wasted? It's the time and the money of the clients. And I have to say, as an attorney, I benefited from that inefficiency. I was paid to do all that work that really shouldn't have been necessary. I had to do it because it's what was necessary to do to obtain a victory according to the incentives and the rules of the public court system. Those were the
part of the system, of course. You're doing your job. It's understandable.
So what has to happen in order to change that is we have to change the system itself so that it doesn't rely on attorneys doing all that duplicative work, doesn't rely on attorneys making multiple presentations to the court, doesn't rely on procedural battles, but instead involves a single adjudicator who is a neutral and dividing the cost of that adjudicator between the parties. That automatically gets you to at least a 50% savings in the cost of your legal fees and other litigation expenses, and probably much, much more.
E-discovery comes to my mind right away, because in some complex, large cases, you would have a team of contract attorneys, document reviewers, spending sometimes years reviewing the same documents as the other side. It's also kind of nonsense, right? What would you say about e-discovery?
Well, let me talk to you about a case that that I just resolved not too long ago. It was a large antitrust case. It involved millions of records, paper and electronic records. It involved all kinds of evidence. And you're right. Each side not only had attorneys, a whole team of attorneys working for the two separate sides, but they also had huge teams of document reviewers, analysts, people that crawled through those millions of records one by one to identify where there was something that was relevant to the dispute, where there was something that helped their client's case, and where there was evidence that perhaps would be troublesome for their client's case. An attorney doing their job has a team that looks for both. But the enormous amount of waste to have not only separate attorneys, but having each attorney team have even larger teams of document reviewers going through all of that evidence to identify the evidence that is relevant to this dispute, either good or bad. Again, enormous duplication of time and cost. All of that.
There's a vendor involved, so each party has to pay to a vendor just to manage all that data. Has definitely
exactly
a lot of money spent. Yes, it's just a waste of resources.
They hire vendors to place all of the relevant evidence on an electronic database that they can utilize for preparing their motions, and then after that for preparing for trial, and then after that for preparing for the appeal. And so all of that is duplication that is unnecessary. Yes, the adjudicator will have to also look at all of those documents and will also have to have a team of document reviewers. But having one team of document reviewers and splitting the cost of that between the parties is 50% more
Absolutely.
than both parties each reviewing the same documents, each having a team that is doing that kind of analysis. The savings is enormous with comprehensive adjudication. Our public court system is structured around what I consider to be a myth, and that is that out of a vigorous debate between two legal gladiators, one for each side, truth will somehow magically emerge. And so that is the system we have. And all of the inefficiency, all of the duplication, all of the multiple presentations that are unnecessary, all of the efforts to achieve procedural advantages are, at their root cause, is this adversarial system that we have because we believe that magically, out of a vigorous debate, truth will somehow emerge. Well, anybody that's watched the presidential debates, for example, probably has some reason to doubt that truth emerges from a vigorous debate. Anybody that goes into that looking at those debates with an open mind can't tell who's telling the truth or what the proper perspective is. And the same is true in court. In court, why should we expect that a jury is somehow going to magically be able to discern the truth out of the exaggerated claims and factual spin of two legal adversaries going at each other in court? That is a myth. Wouldn't it be better to have someone who is neutral looking at the evidence and looking at the testimony and simply deciding what the proper outcome is? And that is why we have this adversarial system. Now, many people are concerned that they need their warrior in their corner. They want a legal gladiator who's looking out only for their interests. And so if you actually believe that you deserve to win, as I think most parties do when they get involved in a law dispute, then what you want is to get to the proper result as quickly and cost efficiently as you can. And that's why comprehensive adjudication, the system that I've come up with, is faster, more cost effective, eliminating inefficiency and duplication, and getting to the right result faster.
Well,
I hope that
you win the case and the other side, unfortunately, has to lose the case, what's the benefit for them? Let's look from that perspective.
Well, there are two ways of looking at that. Number one is, if you ultimately were going to lose the case anyway, because a judge or a jury would come to the same conclusion as the jury does, as the adjudicator does, then why would you want to spend years and enormous extra sums of money getting to the same result? If you have to lose, it's better to do that quickly and cost effectively.
So if at the end you're a winner too, you're saving money. Yes,
exactly.
Time.
If you actually believe that our public court system will ultimately lead to the proper result, then why wouldn't you want to get there faster and less expensively? And if you happen to be wrong in your legal position, then it's better to find out and move on, instead of dragging it out, paying enormous amounts of extra cost, taking enormous amounts of time, energy, and distraction from your normal business or everyday individual activities, to fight it out in a system when you're going to lose anyway. And so if that is the unfortunate outcome of the dispute, get there faster and more cost effectively and move on. That's what is in your best interest. The other thing that you should know is that you have a right of appeal, if you like, in comprehensive adjudication. And this is something we can talk about later in connection with arbitration. But unlike arbitration, with comprehensive adjudication, if both parties agree at the beginning of the case that there is a right of appeal to an independent appellate expert, again, an expert attorney who is an appellate specialist, who is skilled at determining whether legal error occurred in a court decision, or in this case, in an adjudicator's decision. The parties can agree at the very beginning that there will be a right of appeal. They can select the appellate specialist that the appeal can be made to, and the appeal can occur, and it can occur in a fraction of the time that it takes for appeals to our public appellate courts, which usually take years to decide. Here, it would be an appeal would be decided in a matter of months. And so there is a right of appeal that is protected in the comprehensive adjudication system.
That's great. How about one thing I wanted to ask you? How about confidentiality issues?
Well, absolutely. It's important because in legal disputes, there often are there's information that is confidential and that confidentiality should be protected. Let me give you some examples. In a trade secret dispute, the whole issue is about someone stealing another company's confidential information and using it for their own purposes. The last thing that the party that's trying to protect their confidential trade secret information, whether it's an invention or a process or a business method, the last thing they want is for that to become public, because that ruins the trade secret. There is no longer any value to their trade secret because
there's certain protection in our public court system for this kind of cases, right?
Yes, but there are all kinds of fights over what's confidential and what's not.
I see.
The court has to define in what they call a protective order, a confidentiality agreement, or sometimes it's an order of the court, and it's a big fight.
If you're not an attorney, right, and you want to protect your interests, there's just too much to know. There are too many rules to follow. Everything is so complex. And this is one of the reasons why people want to hire attorneys. It seems like the process that you're proposing today, and I know you have been thinking about it for years, it actually simplify things. And I think this is so important. So
first of all, you're absolutely right. In the public court system, everything is overly complex, and you've identified the problem right there. On the confidentiality issue, protecting confidential information in a public court is difficult and complicated. Why? Because it's a public court, and the default is that everything that happens there is open to the public. Yeah. One of the advantages of comprehensive adjudication is it's not in a public court, and everything is confidential. If the parties agree, even the adjudicator's decision ultimately deciding the dispute can be kept confidential. And so if you have a trade secret dispute where the very dispute is over confidential information that you don't want in the public, it's a much better system to utilize comprehensive adjudication, because it is from the beginning, it's not a public proceeding, it's a confidential proceeding. And the same would be true in all kinds of other settings. Imagine we talked about a child custody dispute where there might be expert testimony of a psychologist about a child's psychological evaluation. That's nobody else's business and should not be revealed in a public court setting. And there are things that can be done. It's complicated, but in the public courts, there are things that can be done after a big fight to protect that confidentiality. With comprehensive adjudication, it's automatically confidential. You don't have that.
That's a huge advantage. It's a huge advantage for the company or for individual. I think that's important. I like what you said earlier, that debates are not always the best way to to get to the truth. There's so much negativity in the middle of it. I feel like people need to be more focused on dialogues and finding like common ground, because realistically, people can agree on more things than they disagree on. There's just no conversation going. There's always adversity, like you said. And I like that in this new system that you're proposing, the goal is to resolve it as fast as possible, spend less money, and move on with your life. I think that's what people want, right? Like, who wants to be in some lawsuit for years and have sleepless nights and worry about something? We live once in my lifetime. I don't want to spend 4 or 5 years in some lawsuit. And that's seems unhealthy, but that's what the current situation is for many, many individuals and companies.
Almost every legal dispute, almost every single one, requires years to resolve in the public court system. We're talking about shortening that to a matter of months with comprehensive adjudication.
And then think about the judge that has so many cases too, how they can possibly even focus on some complex case, and then they have, I don't know how many cases they work on at the same time. Can you give me an idea? At least I'm thinking.
It depends on the court that we're talking about, but always at least dozens and usually hundreds of cases at one time. And you're right, it's difficult for the judge to keep focus on the particular details and facts of any single one of those cases. It is much easier for an adjudicator whose job is to just work on this case and get to the truth as quickly as possible, to focus on the details that are necessary to get it done quickly and cost effectively.
Yeah. That's very interesting, very, very exciting, because we need it. It's a matter of fact that the system we have in place right now is just inefficient. And most importantly, many people and many companies cannot protect their rights because it's just too expensive. It's not worth it, and go fight for your rights. It's like, I can't afford it. And this is not right. Everyone should have this opportunity to protect their rights. We're talking about this new system that you're proposing. And, many people would rather deal with old problems than try something new. So I remember you told me that there's some similar systems in other countries, right? And how would we not just talk about the benefits of this system, but also explain it in a way which is very practical? For example, let's take this hypothetical. I'm the CEO of the company, and I have this dispute that is really complex, and it affects me as a CEO of the company and me as a person. What would I do? Which steps do I need to take to use this new system that you're proposing?
All right. Let's assume that the CEO has a dispute with another executive at the company that left the company and started a new company to compete using the confidential information of the company he left. We call those trade secret cases, and that's the dispute.
Okay.
The CEO of company A wants to sue the executive.
That's be me.
That
will be me. Okay. That's my company. I worked all my life so hard. I built the company, and now Mr. Smith worked here for a month, learned everything about my processes, right? And Now, what do we do next?
Well,
I'm still very small, so it's not like I have resources to pursue this lawsuit that my attorney already advised me, right? That would take years and a lot of money, and that lawsuit would kill my company. So what do I do? It's not fair. It's unfair. I would love to, do something about it, but I understand that if I go in this direction, I'm risking losing my company. So what do I do?
exactly.
I just made it up. It's not. It's a hypothetical.
Well, that's actually a fairly common experience, and in effect, you are between a rock and a hard place because you're going to lose your company either way. If your trade secrets are utilized to compete against you, your company will suffer. At the same time, if you spend years and enormous cost in litigation trying to protect your trade secrets, then you will you'll lose your company anyway because of the cost and delay. And so what's your option? Well, comprehensive adjudication provides an answer. Let me give you the step-by-step process that you could
please,
take.
Please, I would love to know.
All right. First thing is you would contact a provider of comprehensive adjudication services. The one that I recommend, because it's my company, is a company called Cases Dispute Resolution. And you would go to the cases website at 𝐾asesresolved.com, and there you would be able to find, how do I get started with a comprehensive adjudication to resolve my dispute?
Mm-hmm.
And you would fill that out, probably take you 5 minutes, and then Cases Dispute Resolution will be in touch with you right away and talk to you about what the nature of your case is, what your claims are, what the dispute is, and what the problem is. And then Cases would offer to contact Mr. Smith, your ex-executive employee who left the company and stole your trade secrets and is now trying to use them to compete against you. And Cases would contact Mr. Smith and say, are you interested in resolving this less expensively, faster, and more justly than you could if there's a lawsuit in the public court system? And Mr. Smith might scratch his head and say, well, I don't think that the information I took from Christina's company is actually a secret. I think it's public information. Okay, well, that would be a valid defense if that's true. So you believe that you are right and that a just result would absolve you of the claim that you stole a trade secret, Mr. Smith. And Christina believes that the information that you took is confidential trade secret information. The best thing that we can do is quickly get to the right result. And Mr. Smith, if you believe that you are correct, then why would you turn down an opportunity to get to that proper, just outcome faster, less expensively? And for all the reasons that I've explained here, I would explain to Mr. Smith that we will get to a proper resolution, an enforceable judgment deciding this dispute, and if he's right, in his favor, and we will do that in less than half the time required for litigation in the court and at less than half the cost, because
guess what Mr. Smith would say? Fine, that sounds good, but can I hire my own attorney? So what would you say?
I would explain the whole process, and I would say, Mr. Smith, the reason why the public court system takes so much time and requires so much cost is that each side has separate attorneys doing the same work, interviewing the same witnesses, reviewing the same evidence, making the same court appearances, arguing the same motions, examining the same witnesses at a trial. And we can cut that cost in half if instead of hiring separate counsel to do all that work and then have a judge or a jury decide it, we hire a single adjudicator, someone that has experience and expertise in trade secret disputes and knows the law in that area and can quickly get to the right decision. And also someone that has experience and skill in reviewing evidence of trade secrets and cross-examining witnesses about what they're doing with that information.
And Mr. Smith will ask, who is that adjudicator?
Right?
Who will appoint him?
Mr. Smith, if you and Christina agree to utilize this comprehensive adjudication system, what we will do is we will find cases, dispute resolution, we'll find 2, 3, maybe 5 expert attorneys that have experience and expertise in trade secret disputes. And you and Christina we will arrange for you to jointly interview each of those adjudicator candidates. And you will be able to determine for yourself whether these candidates have the experience, have the expertise, have the skills, whether they are neutral, whether they have integrity, whether they have any conflicts of interest, whether they have the skills to cross-examine witnesses and get to the truth, and how many years they've been practicing law in this particular area. And then you and Christina will attempt to agree on a candidate that you both agree has the expertise, the neutrality to decide your dispute. If you agree, then we will sign an agreement where Christina and you will both agree to suspend any litigation in court and will instead jointly retain the adjudicator that you jointly select after interviewing this person to investigate all the evidence and all the law that supports Christina's side and all the law and the evidence that supports Mr. Smith's side. And then after doing that analysis, the attorney, the adjudicator will decide the dispute. And that dispute will be, that decision will be enforceable. How can it be enforced? Under the Federal Arbitration Act, if the parties agree to a process such as what we've described, then the decision of the neutral adjudicator can be enforced. And how is that done? The decision is very quickly taken to a public court, and it is automatically converted into a judgment of the court, which has the same power and effect as if there had been a jury trial and a decision in court.
But Mr. Smith would say, what if I disagree with this decision? What can I do?
You and Christina can agree at the beginning of the adjudication process that there is a right of appeal. And you can decide and even select an appellate specialist, an attorney that only does appeals and has expertise in determining whether legal error occurred in a particular decision. You can select that appellate specialist to be essentially your appellate adjudicator. And that appellate specialist will be waiting. And if you disagree with the decision of the adjudicator in the case, you can appeal that decision to the appellate specialist, who will then decide the appeal. And that appeal will be decided in a matter of months instead of years, which is what it would require if you were going to an appellate court in our public court system.
And then Mr. Smith would say, that sounds good. Actually, I might think about it, but it sounds just like arbitration to me. What's the difference?
The difference is that arbitration suffers from the same fundamental defect that litigation in the courts suffers from. And that is the reliance on separate attorneys reviewing the same evidence, taking the same testimony, analyzing the same legal authorities, and presenting evidence at a same trial, or in the case of an arbitration hearing. And so you are still paying for this duplication of effort. And not only that, on top of the cost of your separate attorneys, you're also paying the cost of the arbitrators, and they are expensive as well. Sometimes it's one arbitrator, sometimes in an arbitration agreement, it's a panel of 3 arbitrators. And so you're paying not only your separate attorneys, but you're also paying the cost of arbitrators to listen to that dispute. And so, the problem, again, is that the excessive cost of litigation in an adversarial process is the same in the arbitration system as it is in the public court system. But on top of that, there are other problems with arbitration. Arbitration usually is the subject of court battles that sometimes take years before the arbitration can even begin. What's the court battle over? It's over whether the case can even be arbitrated in the first place. There are frequently disputes over whether the agreement to arbitrate is enforceable. And those disputes take years, and they take place in the public courts. And that's before the arbitration even begins. The other problem with arbitration is that there are very limited rights to pre-hearing discovery in advance of the arbitration hearing. And so it is very difficult, if not impossible, to take depositions or to subpoena documents in advance of the arbitration hearing.
Yeah, seems like it's complex as well. Just another option, but there are not that many benefits.
Arbitration decisions cannot be appealed except under very, very limited circumstances to a public court. And so the decision of the arbitrator, right or wrong, is the decision that you have to live with. It is not error in an arbitration proceeding for the arbitrator to listen to inadmissible evidence, for example. And so arbitrators and arbitration proceedings usually last much too long because the arbitrators listen to whatever the attorneys want to present to them, whether it's relevant or admissible or not. And so arbitration proceedings can often go for much, much longer than is necessary to decide the dispute. And you're paying your separate counsel and the arbitrators for all of that. And then if the arbitrator's decision is improper or in error, you have no right of appeal. All of the problems with arbitration are solved with comprehensive adjudication. The adjudicator subpoenas documents that are relevant to the dispute before making the decision. The arbitrator does the cross-examination of the witnesses, personally examines the witnesses in advance of making a decision. And if the parties agree to a right of appeal, the decision of the adjudicator can be appealed to an appellate specialist, as we described earlier. All of those problems with arbitration are solved through comprehensive adjudication.
Right. And no, thank you very much for that. And there was another part of my question. Then I said, just a human nature for us to deal with our old problems is easier than trying something new. And I know that you mentioned in the past that there's something similar has been implemented in other countries somewhere in Europe. Could you please talk about it a little bit?
Yes, absolutely. And I think the expression you were searching for is we have a human tendency to just go with the devil we know. We don't like the public court system. We don't like the cost and the duplication and the inefficiency and the delay and the risk associated with litigation in public courts. We don't like it. We hate it. And yet it's the devil we know. And because we're familiar with it, we have a human tendency to go with it anyway. Well, you're right. Something very similar to comprehensive adjudication has been used for decades in other developed countries. Let me give you some examples.
Please.
In the United Kingdom, if there is a dispute involving a construction project, the parties are required to adjudicate the dispute that they have rather than spend years in litigation in court. And why is that? Because imagine a dispute between a general contractor and his electrical subcontractor in the construction of an office building. Ordinarily, the leverage that the subcontractor utilizes when there's a financial dispute between the parties or a contract dispute is they walk off the job and say, I'm not doing any of the work that I was contracted to do to build this building until we get this worked out. And the construction of the project comes to a halt. The British government said that is not helpful to anyone because litigating that contract dispute or financial dispute in court will take years. And in the meantime,
it doesn't make sense. Yeah.
The construction comes to a halt. So what can we do about that? They created a system that's similar to the system that I've come up with, where the parties to the dispute adjudicate the outcome. And instead of hiring separate counsel, they go to an expert in construction law and construction contracts who is a neutral, like an adjudicator in my system, who looks at the claims of the electrical subcontractor and the defenses of the general contractor and decides the dispute expertly in a matter of months instead of a matter of years. And the quid pro quo is that because we are going to get this decided for you, Mr. Electrical Subcontractor, in a matter of months instead of years of litigation, you have to promise to stay on the job and to continue your work. If you deserve to get paid more money, we're going to decide that within a matter of months and you will be paid. And that will be a benefit to you. Because, yeah. Same thing with financial disputes in other countries. For example, in the Netherlands, if there's a dispute involving an insurance company, a dispute involving a bank, a dispute involving financial advisors, investment advisors, all of the entire financial industry, if there is a dispute, there is a system there that is run by the government where there's a similar system. Instead of the parties hiring lawyers and spending years in pointless disputes and procedural battles and duplication of effort and unbelievable cost, they hire a neutral. In this case, it's a government, an employee of a government agency that has expertise in financial disputes, to decide the dispute in a matter of months instead of a matter of years. These systems have been successful in resolving and coming up with solutions to disputes in the financial industry in Holland or in the construction industry in the UK for decades, and it's been very successful. So while this is something that is not commonly in use in the United States, you can take comfort in the fact that this process has been used successfully in a whole variety of other developed economies to save money for the parties in a dispute and get their disputes decided faster and more cost effectively. But let's go back for a moment to your dispute with Mr. Smith, who left your company with your trade secrets and is now using your company's confidential information to compete with you. So you and Mr. Smith would interview a variety of adjudicator candidates and would agree on one of them to be the best person to decide your dispute. And then you would agree that you would suspend any litigation between you and the public courts, and you would abide by the decision of the adjudicator, or if you agree to an appeal option, to the decision of the appellate specialist. And then the trial would begin immediately, not 5 years down the road, not 3 years down the road, immediately.
The agreeing part can take a while too, because me and Mr. Smith, we really don't like each other anymore. So I don't know. For us to agree, even on the adjudicator, that can be challenged too, you know?
Well, that is challenging, but it happens all the time, because in the arbitration system, which you mentioned earlier, the parties have to agree on an arbitrator. And so it takes some time, but there's a process for reaching agreement. And this happens with thousands of arbitrations every year. So even though you and Mr. Smith are not fond of one another, you can probably agree on one of the candidates to be someone that will do a good job as an expert to decide your case. And if not, if you don't like, you can't agree on any of the 5 candidates that cases dispute resolution found for you, cases will find you 5 more candidates to interview.
That's good. So
we will
agree, right?
Eventually you will agree, because it's in both of your interests to do this. At some point, if you can't agree, then what happens? You end up in the public court system wasting all kinds of money and time.
That's a good point.
So you both have an incentive, a strong incentive, to agree on someone that's competent, and not only competent, but expert in deciding these cases and getting to the truth quickly and cost efficiently. So you will agree on.
There's going to be a financial aspect to that, right? So Mr. Smith would say, I want somebody who's more experienced, but of course that person can be more expensive per hour, right? Is that how it's going to work?
Well, we don't know what their rates are, but one of the considerations that you would ask them about in your joint interview of them is, how do they charge and how much? And that would be something that both you and Mr. Smith could consider in making your decision. But ultimately, think about this. Even if they are a little more expensive because they have some expertise, you're splitting the cost.
Exactly. Great point.
So if you cut that in half, it's going to be less expensive than anyone else that you could hire as your separate counsel.
Yeah, go try looking. Okay, you think if he's too expensive, go try looking for attorneys, and then you'll run back to split the bill here.
That's exactly right.
Interesting.
And so the trial then begins immediately. Your adjudicator subpoenas the relevant documents from both you and Mr. Smith, and any third-party witnesses that may have documents or evidence. The adjudicator looks at those documents and then takes your deposition and cross-examines you and tries to find all the evidence and testimony that supports your position, but also looks for all the evidence and testimony that might support Mr. Smith's position.
Absolutely.
And then the adjudicator cross-examines Mr. Smith and does the exact same thing, looking for all the evidence that supports Mr. Smith's position, but also looking for all the testimony that supports your position, and cross-examines him intensively to make sure that we're getting to the truth. And then,
any need an expert?
If an expert is required, because the trade secret involves some, scientific issue that is beyond the adjudicator's legal training, and then an expert will be retained to provide an opinion.
One except for two, right?
Yes, one instead of two. And instead of it taking years to get to a decision, it will, in a matter of months, the adjudicator will have examined all the evidence, examined all the testimony, focused in on the law that's relevant to this dispute, and then will decide the dispute. And that decision will be final and enforceable unless you've agreed to a right of appeal, in which case one or the other of you could appeal. Of course, only if you can demonstrate to the appellate specialist that the adjudicator committed some legal error. But if you can, then you have that right of appeal. And that appeal will be decided in a matter of months instead of a matter of years. You will save enormous amounts of money in legal fees.
So I can pursue this issue. Otherwise, I wouldn't be able to. So I don't have extra funds, remember, for this lawsuit, because I would lose my company if I even began thinking about it, discussing it with attorney. That's a small company, but it has a big future, right? And here's Mr. Smith. So yes, at least there's an option for people or for companies that believe that they cannot even cannot afford to start the process in the public court system.
Right. Now, you or Mr. Smith or both of you might say, well, I understand that by having the adjudicator do the lion's share of the hard, expensive work and splitting that cost, we both save a lot of money. But I'd still like my separate attorney to be involved in some way. Is there a role for me to have my separate attorney involved in this adjudication to make sure that my rights are being protected? And the answer to that is yes. You are not required to have a separate attorney like you are in the court system or in arbitration, but you may optionally involve your separate counsel in aspects of the case. How can we do that and still save you money? Well, your separate counsel can be helpful at the very beginning of the case in framing the scope of the case. What is this dispute about? It's about trade secrets. It's not about Mr. Smith stealing money on his expense account while he was employed by you. This is just about the trade secret case. Or maybe you want to include both issues for the adjudicator to decide. But your attorney can spend a little bit of time helping to frame the dispute for the adjudicator. This is what the complaint is. This is what and Mr. Smith can have his attorney say, well, these are our defenses. We don't think it really was a trade secret. We think it's public information that we're using. And that frames the dispute for the adjudicator to go forward and then investigate the law and the facts that are relevant to that dispute. The other thing that your separate counsel can do, if you want to pay them to do it, is to not do all the intensive, expensive work, but simply look over the adjudicator's shoulder and monitor the work that the adjudicator is doing. And that way you can have, if you're willing to pay a little bit extra to your attorney to to just monitor the proceedings, you can have the satisfaction of knowing that somebody with some legal expertise is keeping an eye on the situation.
So what you're saying, if I'm understanding you correctly, is just a different level of involvement, right? You would still save money, you would still save time you spend with your attorney, but just for your peace of mind, if you want the attorney be involved, it can happen. It's okay. And some of the companies, if it's a middle size or a large company, there are attorneys, in-house attorneys in those companies. So they can also play that role that you just described, right?
Exactly. And so you can, yes, you let the adjudicator do the heavy lifting, the time-intensive, expensive work, and you split that cost. But if you like, you can pay your separate attorney to keep an eye on the work that the adjudicator is doing and to monitor that work. And I should add that cases dispute resolution, as part of their role in administering the adjudication, will hold monthly status conferences with the adjudicator and with the parties, so that you and Mr. Smith will be on a call or perhaps meet the two of you in person with the adjudicator, so that you can say, what have you done this month? What witnesses have you talked to? Are you going to talk to these other witnesses that I've identified for you?
Right, and this is where you maybe in-house attorneys can play a role, maybe attend that meeting, or if that's just an attorney that you want to hire for a couple hours here and there, not just being involved, working full-time, right? That would be a good time for them to attend, review the documents, and just give you an assessment, second opinion on the process.
Yes. So if you want your separate attorney to participate in a 2-hour conference call with the adjudicator to find out what's being done and how it's being done, that might be worthwhile to you, but it's a very minimal expense compared to what you otherwise would be doing in public court. And then the final role for a separate attorney is to advise you, and Mr. Smith can have his attorney advise him on settlement. There may be a time when both you and Mr. Smith want to explore resolving this dispute amicably instead of waiting for the adjudicator to make the adjudicator's decision. And as your attorney is monitoring the work that the adjudicator is doing, your attorney can advise you, I think this looks strong for you, but this part doesn't look so good for you. You might want to consider settlement. And you can get private, independent advice on that from your separate attorney. I should mention that the adjudication process has built into it opportunities for settlement. The adjudicator does not get involved in settlement discussions. The adjudicator is walled off because the adjudicator is neutral and is not involved in negotiating a settlement. But when the adjudicator has completed the adjudicator's investigation, taken all the testimony, recorded that testimony in deposition transcripts, and also has reviewed all of the documents and other evidence, the adjudicator prepares a compendium of all the evidence, both testimony and physical evidence, that the adjudicator believes is relevant to the adjudicator's decision. Now, you might have testified that the information that Mr. Smith took with him is confidential information of your company. Mr. Smith might have testified, no, it's not. This is information that's in the public domain. Everybody knows about this. It's not a trade secret and not subject to protection. That's conflicting testimony. The adjudicator would identify both your testimony and Mr. Smith's testimony as relevant to the adjudicator's decision. Now, the adjudicator won't at that moment be deciding or telling you which testimony the adjudicator believes is correct, is more credible. But the adjudicator would identify your testimony and Mr. Smith's testimony as relevant, and all the documents that show whether this is a trade secret or not. At that point, the adjudicator will publish to both you and your attorney, if you have one, and Mr. Smith and his attorney, if he has one, the compendium of evidence that the adjudicator believes is relevant to the adjudicator's decision, and give you 30 days to analyze that evidence and explore settlement discussions if you feel that is a good idea. Now, your attorney might say to you, I think your case is rock solid. Don't settle the case. I've looked at all the evidence that the adjudicator is going to consider, and there's no way that the adjudicator can decide against you, in which case you would just let the adjudicator decide. But in most cases, there's evidence on both sides.
I was about to say that.
There's going to be evidence that helps you, and there's going to be evidence that hurts you. Your attorney might say, well, you testified that it is a trade secret. Mr. Smith testified that it's not. It's a flip of the coin which testimony the adjudicator is going to decide, is going to believe is most credible. And so you have an incentive, because of the risk that you might lose, to settle the case. In which case, and Mr. Smith's attorney may be privately advising him the same thing. And that would be a reason why the two of you might sit down, perhaps with your separate attorneys present also, and try and negotiate a settlement. If you need more time than 30 days and you both agree, then the adjudicator will give you more time. If you don't agree that you need more time, then the adjudicator will decide the case 30 days later. And then that decision will decide whether you are, whether Mr. Smith is liable to you for stealing your trade secrets. If the adjudicator says no, he's innocent, the case is over. If the adjudicator says, yes, Mr. Smith is liable, the information he took was a trade secret belonging to Christina's company, and he is liable for theft of trade secrets, there will then be another 30-day period where you and Mr. Smith can negotiate what the damages should be, and perhaps reach a settlement based on whether you're entitled to $1 million or $2 million for that theft of trade secrets, or something in between. During that 30-day period, you can negotiate the remedy, in other words, the damages that you are entitled to receive. If you don't reach a settlement after 30 days and jointly request more time to negotiate, then the adjudicator will decide you're entitled to $1.5 million. Case over. The case is the decision of the adjudicator on liability, and if appropriate on damages, is the adjudicator's decision in the case. And that can be taken to a court of law and very quickly converted into a court judgment. That's just as enforceable as if you had tried the case in court 3 years later instead of getting it done in a matter of months. And so it can be converted into a judgment. And again, if you've agreed at the outset that Mr. Smith has a right of appeal, then we can have an appeal to a private appellate specialist, and that will be decided in a matter of months instead of years. And the case will be over. Again, if you win and Mr. Smith loses, it is better for Mr. Smith to find out that he's going to lose this case, deal with it, and move on with his business life without using your trade secrets. And to do that faster and more cost effectively. And what comprehensive adjudication can promise you is that you will save at least 50% of the cost, because you're splitting the cost of the adjudicator instead of paying your separate attorneys to duplicate each other's work. It will happen in half the time or less. And you will have a more thoroughly, more expertly analyzed decision because you're using an expert in the field of law, in this case, trade secrets, to decide the case instead of a judge that might have been trained in criminal law and a jury that is not trained in making legal decisions at all. So those are the advantages: a more expertly decided decision in less than half the time and in less than half the cost. And you can imagine, we're just talking about a case that involves two parties. Sometimes there are multiple parties in a lawsuit, in which case the savings would be dramatically less. You'd be splitting it 3 ways or 5 ways instead of each of you having separate attorneys to duplicate each other's work. And so the savings in time and cost would be multiplied exponentially.
I see this encouragement throughout your new process for the parties to have that conversation, to try to understand. Maybe Mr. Smith really didn't realize that that was confidential information, that was a trade secret. So at some point he realized that, and he's like, okay, maybe we can settle at this point, right?
Exactly. And, a settlement requires both parties to agree, whether that's a settlement in the midst of a court proceeding, a public court proceeding, or a settlement in the midst of a comprehensive adjudication. We provide formal opportunities where it makes sense for the parties to look at the evidence that the adjudicator is going to make the adjudicator's decision on, and then analyze that and say, oh, I didn't realize that there was this fact or this document or this testimony. Now that I understand that, I'm prepared to compromise and make a settlement.
Reevaluate your position, of course.
Exactly. And so the system works far more efficiently, far more cost effectively, much faster, and the decision is more expertly decided. There's no way that you can rationally turn down that opportunity. And in fact, at the very beginning, when you call cases dispute resolution and say, how do I, can you approach Mr. Smith and see if he'll agree to this process? This is a strategically fabulous thing for you to do, whether Mr. Smith agrees or not. And here's why. When I go to Mr. Smith and say, Mr. Smith, you have the opportunity, if you earnestly believe that you are in the right and that Christina's claim against you is bogus, then you would want to get to a decision that you are correct faster and less expensively. Half the time, half the cost, to get to a more expertly decided decision. And if you believe you're right, you have no basis for turning that down. You'd be crazy to turn that down.
Right. Okay? It just
if he does,
warning, I'm going to sue you. So that's
right. Yeah. Okay. All right. But Christina, think about this. If despite that compelling choice that he has, he says, no, I don't want to do that. I'd rather spend more money and more time and undertake more risk to go
and I know that good attorney.
then you would find out immediately that he doesn't really believe that he has a strong position. Because if he really believed he was in the right, he would want to get to a decision faster and cheaper. So
that's a good point. Yeah.
even if he turns you down,
Right. The attempt to
you
take
have
this
a
to the road.
you have the strategic advantage of knowing that he really doesn't believe that he's in the right, that he's turning you down because he doesn't want to get to a decision faster and cheaper, because he doesn't really think the decision will favor him. And so that strategic knowledge that you just gained, even though he turned down the whole comprehensive adjudication process, that strategic knowledge that you just gained tells you, yeah, I need to go to public court. That's my only remaining option. But if I can just hold out, I'm going to win, because not even Mr. Smith believes in in his own position. He really thinks he's going to lose, because if he thought he was going to win, he'd want to get to that winning decision faster and cheaper.
Right.
So it is always a good strategic move
as a first step to reach out,
to propose comprehensive adjudication and see what the other side says. You learn a lot if they turn it down.
Mm-hmm.
And if they accept, then you get to the right decision faster and less expensively.
Yeah, that's good.
And it costs you nothing to have cases dispute resolution reach out to Mr. Smith and propose this to him. So you either win because he accepts, or you win because you learn that he doesn't really believe in the strength of his position. Either way, you win by proposing it, and it costs you nothing. And so it makes sense to always propose comprehensive adjudication, regardless of what the answer may be.
And then you're reaching out to Mr. Smith. It's not for free, right? You're saying it's cost you nothing. I don't know if it's...
Well, no.
No?
Cases dispute resolution doesn't charge you a penny to call
Reach out to Mr. Smith?
Yes, and propose this to Mr. Smith.
Oh, that's great.
Yeah, you only get charged if you agree, both of you, to comprehensive.
So this is the point in time. Oh, that's actually great, because somebody will reach out to Mr. Smith and he might just want to settle right away. Who knows?
Or if he doesn't want to settle, then he wants to, maybe he'll agree to engage in the comprehensive adjudication process, and both of you will save time and money.
Absolutely.
So it is a strategically smart thing for you to do, to have cases dispute resolution propose this to Mr. Smith, to your adversary, and either way you win.
Yeah, and I wanted to reiterate that it's not only applicable to small or large companies. If, for example, I'm a woman and I'm going through divorce, and I think I don't have extra money to pay attorneys, and divorce cases can take years too.
Yes.
So maybe that's an option for me as well.
Correct.
I'm not going through divorce right now, by the way. I'm just my hypotheticals.
No, hypothetical. Well, and that's actually often the case, that in a divorce, there's a certain amount of money at stake. To the parties involved, it's, perhaps their life savings, or their home, or other things that are immensely valuable to them. But the attorney's fees are going to eat up all the value of what they're arguing about. So if you're arguing only about $150,000, well, that's a lot of money to a couple whose whole life savings is $150,000. But if the attorney's fees are going to cost $100,000 for each party, everything gets eaten up by the attorney's fees, and not to mention the emotional distress of going through years of litigation with your ex. And so why would you
can't
do that?
move on with their lives? Yes, it's not only financial aspects, but you're right, years of just dealing with it. Can be
Right.
very stressful, not just for that couple, but for children as well.
Absolutely.
I don't
Yes.
have that experience in terms of litigating in divorce matter, but I'm just assuming I think I'm right.
Absolutely. And it makes sense for you to jointly split the cost of an adjudicator who will investigate the facts and the law and will say, okay, this property is community property and needs to be split between the husband and wife. This property is not. And all kinds of decisions like that, the parents, you want custody and you want custody of the children. The proper decision here under the law is joint custody. You'll have visitation on these days. You'll have visitation on these days. All those things to get to a proper decision quickly and inexpensively instead of, wasting all of the couple's assets on attorney's fees makes an immense amount of sense. So you're right. It applies in small disputes. It applies in very, very large disputes, large antitrust disputes, patent disputes, trade secret disputes, contractual disputes, securities fraud. All of these kinds of disputes are big and monumental. It is always more economical, always faster, always better to get an expertly decided decision if you believe that your position is correct.
So this process works well for any case, large or small individuals or corporations.
Exactly. The only circumstance that I can imagine where this would not work well is if you are a party to a dispute and you know that you are wrong. If you know that you're wrong, then you don't necessarily want to get to a decision in that, faster.
And you have money to drag that case for a long time. That's the worst scenario, unfortunately.
And honestly, I only want to work with parties to disputes where both parties believe, at least at the beginning, that they're correct. And in my long experience advocating on behalf of plaintiffs and defendants, what I have found is that at the beginning of a dispute, both parties almost always believe that they're correct. And it's only through the process of uncovering the facts and the law that they learn, maybe I'm not correct about
I didn't know about that.
Exactly. And so it is that process that leads people to have a better understanding of what the law and the facts are. And that can sometimes lead to a settlement and sometimes not. What I want to say is that for folks that are facing a difficult legal dispute and trying to decide what to do, as we described earlier, it always is to your benefit to propose a comprehensive adjudication. So you can get more information about this in two separate ways. If you have a specific dispute and you're looking for the opportunity to explore using comprehensive adjudication instead of public court litigation to resolve it, contact Cases Dispute Resolution at their website, casesresolved.com. Let me repeat that, casesresolved.com. The whole process is described there in great detail, and there is an online form that you can fill out, take you 5 minutes to say, I'm interested, I want to explore this. Can I have someone from Cases Dispute Resolution contact me to discuss proposing this to my adversary? That's at casesresolved.com. If you're just generally interested in comprehensive adjudication in general, and want to learn more about it, how it works, including the rules of procedure that have been promulgated, including the best practices. There's a statement of best practices for adjudicators at a nonprofit that was founded to oversee the comprehensive adjudication industry and oversee and educate the public about the availability of comprehensive adjudication. That's at intelligentjustice.org.
That's great. And I would strongly encourage law students to visit your website and learn more about it, because we really, really need some changes in our legal system, because we want justice for all. So please, if you're a law student or you would like to pursue your career as a lawyer or as a paralegal or any other legal professional, I think that is very informative, and there are a lot of useful information you can find on Rick's website.
I appreciate that, and thank you for the opportunity to talk with you and for helping to get the word out to the public about this opportunity to resolve cases more cost effectively. Before we end, I do also want one other benefit of comprehensive adjudication. Not only does comprehensive adjudication guarantee that the cost of getting to a proper decision will be half or less the cost of going through litigation in the public court system. But with the comprehensive adjudication process, the adjudicator can tell you at the beginning what the process will cost and can cap the cost to the parties. How is that possible?
Yeah.
Well, no lawyer will do that in the public court system because they don't know what's going to be involved when you have adversaries fighting with one another and seeking all kinds of procedural advantages. No litigator can tell you this is how long it will take and this is the most that you will be charged.
Absolutely. Yeah.
But an adjudicator can. An adjudicator, before you go forward, the adjudicator will say to one party, who are the witnesses to these events? Give me their names. What are the documents that I should look at in order to understand what happened? Was there correspondence? Were there agreements? Were there emails? Tell me what there is. And then goes to the other side and says the exact same thing. Who are the witnesses that you think I need to examine in order to understand this? What are the documents that I need to review? What is the law that is involved? Is this a trade secret case? Is this a divorce? Is this a patent case? Is this a contract dispute? At that moment, once the adjudicator knows the scope of what's involved, the adjudicator can make very accurate estimates of how much work will be required to examine those witnesses, review all those documents, and research the law. And can say, I guarantee that the cost that the two of you will divide will not exceed X, and cap that cost at the beginning. And then you will split that cost and pay in.
Huge, what you're saying now, it's huge.
Yes. You can even make arrangements to take that cap cost. And if the adjudicator says it'll cost X total, and I can do all this work in 7 months, you can divide that X dollar figure in half and then take those halves and divide them into 7 equal payments to the adjudicator, because the adjudicator has capped the cost to you.
Yeah.
This is huge because one of the problems with litigation is that 1 month it costs $500 and the next month it costs $5,000 and the month after that it costs $50,000 or $500,000.
And you don't know for how long it might go.
And you don't know.
The history.
It is an uncertain process. The ability for individuals, or for that matter, companies, to cap the cost and then pay it in equal, reliable, predictable monthly installments is huge. It means that the company's legal department has the ability to budget for the legal cost and know what it will cost before they even get started with this process.
Yeah.
Same thing with an individual.
Yes, they're individuals, then they get into some lawsuit. They don't expect it to go for 5-6 years, and before you know, here we are, right? It's like, why didn't you tell me that, right? They can ask attorney, but the attorney can't predict things like this. Yeah.
That's exactly right. And that is why.
But there's
that is
yeah.
Yes, and that is why most cases settle. The vast, vast majority of cases settle. Not because one side realizes that they were wrong and the other side says is right. They don't settle because of the merits. In fact, if you go to mediation, what is the lever that the mediators always use? What they say is to Christina, I see your claim, your trade secret claim against Mr. Smith. You have some very valid points here. You might win, but you know what? Look at what it's going to cost you to get a final enforceable verdict after appeal. Ask your attorney's sitting right next to you in this mediation. Will they tell you, will they cap the cost to you? How much is it going to cost? All right. So would you consider compromising your position by half the amount that your lawyer is going to charge you to get to the result that you want, even if you win? And then the mediator goes in the other room and says to Mr. Smith, hey, Mr. Smith, you have some interesting defenses. You might very well win this case. Okay? But ask your attorney, how much is it going to cost for you to litigate this all the way through and get an enforceable verdict that you are not liable in this lawsuit? Will your attorney agree right now to cap the cost that your attorney will charge you? Maybe what you should do is look at what it will cost to litigate this all the way through. Even if you win, it's going to cost you X. Maybe you should compromise your position in settlement by half of X.
Like everyone is losing in the end. You know?
Exactly. That is the leverage. I mean, I've been in a million mediations. Every time the mediators, they don't talk about who's right and who's wrong. What they talk about is the cost and delay that will be required in order to get to a point where you might win. Oh, and by the way, Christina, by the way, Mr. Smith, you might spend all that money and you might actually be right. Maybe you should win. But this is going to be decided by a judge that doesn't know anything about trade secret law. This judge was a criminal lawyer for 40 years before she became a judge. Or it'll be decided by a jury that has no training in making legal analysis at all. So, sure, you can invest all that money that your attorney says it's going to require to get to the end point, but you may end up with a result that is unjust anyway. So,
and all your confidential information going to be out there for years. Right?
And the mediators use cost and risk of continued litigation to force the parties to settle. And what happens when there's a settlement? In order to have a successful mediated settlement, what's required? Both parties have to compromise their position. And that includes the party that deserves to win.
Mm-hmm.
And so is that justice? It does resolve the dispute. You're done. You can move on with life. But the party that deserved to win had to make substantial compromise in their position in order to reach a settlement. And they did so not because they were right or wrong, but because of the continued cost and risk of going forward with litigation to get the result that they hoped for. And so the good news is mediation can still be utilized to settle cases in the context of an adjudication. But the mediator won't be able to use the cost and risk of litigation to force a settlement, because the cost will be substantially less and the risk of a poorly decided result also will be less, because you've got it.
Yes.
Again, to learn more, go to intelligentjustice.org. If you have a specific dispute that you want to explore using comprehensive adjudication to resolve, then go to casesresolved.com.
Great process that will benefit many, will benefit individuals, companies, and the system overall. It will take some weight off the court system, right? That they barely can handle, they get behind on their cases. So I think it's good overall. From any perspective you look at this, there are benefits everywhere. So thank you very much for that.
And thank you for this opportunity to explain this system and get the word out there. I think this could be a huge, huge development in improving our system of dispute resolution.
Thank you. Thank you for your time, Ri.